Hi, this is a recording for the material covering Chapter 3. Chapter 3 is going over the entire adversarial system from start to finish. Also goes over some ADR, which stands for Alternative Dispute Resolution, and then some Prefiling Investigation talk. So let's start talking about criminal law and civil law and how they are different, because we know that they're not the same. And there's many different ways that you could point out differences. However, there's three in particular that I'm thinking of, and they are the burden of proof, the penalties, and the parties. So think about those and how they're different between civil and criminal law. Let's start with the burden of proof. This is what has to be proven in a case. What standard has to be proven in a case in order for the plaintiff or the prosecution to prevail. And in civil law, it is a preponderance of the evidence, which means more likely than not. Okay, that's your standard, that's your burden of proof. In criminal law, the burden of proof is beyond a reasonable doubt. And that is not 100%, but it's pretty darn close to it. So it's a much higher burden than civil law is, and that's only because, as you can imagine, there's so much more at stake in criminal cases than there are in civil cases. So that's why the burden of proof is different in those. As far as the penalties go, in criminal law, you've got imprisonment and or fines. Okay, those are the penalties. And then in civil law, you've got damages, and those are normally awarded in the form of monetary damages or monetary awards. But sometimes they could be equitable awards, such as an injunction in trespass to land case comes to mind. Parties are different between civil and criminal law. In criminal law, the government is involved. Like I said just a bit ago, the prosecution is the one that's going to be bringing the charges against the defendant in that case. So you've got either federal, state, whichever level it is that's bringing the case against the defendant. In civil law, you've got individuals, groups of individuals suing one another. So that's a little bit about how civil law and criminal law are different. There are many different ways, many other different ways, but those are mainly the highlights or the main points. Another way that they differ, and we'll talk about this throughout, is the terminology that is used in civil and criminal law. And a lot of newbie paralegals get mixed up with those, so I'll point those out as we go through them. As far as the U.S. court system goes, I'm sure that you guys have learned this several times in your academic career, so we're not going to spend too much time on it. But generally, as a refresher, in both of the court systems, you've got a Supreme Court, which is at the very top, right? That's the court of last resort. Then right underneath it, you've got appellate court, followed by the lower trial courts, inferior courts, JP courts. So basically, you start out at those lower levels. That's when you are filing the suit or bringing the charges. And then if you have a basis to file an appeal, you'll take it to the appellate court, which is right above that. And then if you are able to do so, you could appeal from the appeal to the court of last resort, the Supreme Court. And that is at the very top of our U.S. court system, or the pyramid. Rules of procedure. Rules of procedure are just that. They're the rules that you have to follow when you are filing and or defending a lawsuit. And there are federal rules of procedure, state, and appellate. In Texas, for instance, we follow what's called the Texas Rules of Civil Procedure. And this is our Bible, so to speak, for civil procedure. Anything that you would need to know in regards to those rules, you know, what I need to do or what my lawsuit consists of, when an answer has to be filed, all those kinds of questions that come to mind you're going to find in the rules of procedure. Rules of evidence. These rules help the judge to decide what comes in at trial and what stays out. Only that information that is relevant and material comes in. Everything else is excluded based on unreliability or prejudice of that evidence. And you've got your rules of evidence at your federal and state levels as well. In addition to the rules of evidence and the rules of procedure, you will also have to consult the local court for their own rules. Now, these rules are not going to conflict with procedural rules in any way, shape, or form. However, they will just be court or judge specific like rules. You know, certain days that the judge wants to hear motions, for instance. So you will find these rules usually on the court's website if they have one. If they don't, very small counties still might not have a website. So you just call up the clerk and you ask them if there's any special rules for filing whatever document you plan to file. So for instance, motion for summary judgment is one that is normally done differently in each court. So if I'm filing this, then I will look on the website and see, does the judge want me to file this through submission, which means just through written motion? I will file my motion and the judge will read the motion and will either grant or deny the order. Or if the judge wants me to set it for an oral hearing, at which time there are certain days and times that I have to set that according to that judge, according to that court. So I will have to set it at that time. And then because it's an oral hearing, I have to show up. The opposing side has to show up and we'll argue this motion in front of the judge. And then at that time, the judge will render a decision on the judgment. So that's just an example of how the local court rules might play out. Here are the stages, basic stages, I should say, of a civil lawsuit. And this is something you want to become familiar with because it's important to know where your case has been, where it's headed. You know, when I first started at the law firm, I didn't have a clue. And they had me doing stuff towards the tail end of the whole process, which is the execution of the judgment. And at the time, I couldn't, for the life of me, figure out how to piece it all together. Well, how exactly did it get to this point? And so this would have helped. So again, you want to familiarize yourself with this. Basically, you'll start out with an incident that gives rise to a civil wrong, leads to an investigation. At that time, there may be some pre-filing investigation, possibly some pre-filing settlement talk, and if that doesn't go through, then go ahead and file suit. You'll serve the other party with the lawsuit. That's service of process. That's formal service where the constable, sheriff, private process server is literally handing the documents, handing the citation and the petition, the complaint to the defendant. You know, you are served kind of thing. That's service of process. If the defendant does not file an answer to the lawsuit, then you get what's called a default judgment. And you can execute on that judgment, which means that you can collect if the party fails to pay you. Or going back, if the defendant does file an answer after service of process, then the process gets a little bit more tedious. You've got discovery to get through, and discovery involves the gathering of facts and evidence, and that can be a rather lengthy process. Then you've got trial, which is another lengthy process in and of itself. Eventually you'll get to judgment for the prevailing party and then possible appeal. So let's talk about the details of a civil suit. First of all, the cause of action. When a plaintiff files a lawsuit against a defendant, she is said to have a cause of action, which is a legal theory and its respective elements that gives the plaintiff a basis in law and fact in which to proceed. The defendant is then assigned financial responsibility, also referred to as liability. So this is where that terminology comes in. Remember, I just said that there's differences between the terminology with civil law and criminal law, right? So in civil law, we speak in terms of liability. We say that the defendant is liable to the plaintiff for the tort, or not liable. So we don't say guilt. We don't talk about guilt or innocence at all in civil law. That is wholly incorrect. So you will only talk about guilt in criminal law. In civil law, what do we say? We talk about liability, okay? Once liability is set, then the goal is to compensate the plaintiff. The cause of action or the legal theories will come from either the court decisions, which is known as case law, statutes that are laid out by the legislator, constitutional law. These are all considered primary authority. And you guys will learn about these in your legal research and writing classes. But that's the origins of where we get the civil suit or causes of action. Our complaint, or original petition, how we refer to it in Texas, is how a plaintiff initiates the legal process. So on this complaint, on this petition, there is a caption at the top that has the parties' names. You guys have probably seen this. Parties' names on one side, you know, plaintiff versus defendant. On the other side, it's got the information about the court that it's being filed in. At the very, very top, there's a place for a case or cause number. Initially, this will be blank. So literally, it'll say case number blank or cause number blank. And the reason why you leave this blank is because you don't have this information yet. The clerk of the court will assign you a number for your case once you have paid all your applicable fees as a plaintiff, okay? So case cause number, court number, that will be left blank. You will get that assigned to you by the court clerk once you pay your fees for filing that lawsuit. But in a complaint, the plaintiff is basically saying, here's my problem, names the person that has caused the problem, i.e. the defendant, and how much is owed as a result. In your complaint, you should list out the elements of your cause of action. So for instance, I gave you guys the example last time in Chapter 1 with the negligence claim, right? And I said that the elements of negligence are duty, breach, causation, and damages. So that's what you want to state in your complaint. So you would state that the defendant had a duty to do something, breached that duty, caused the incident, and is now responsible for the damages based on that. Let's talk about the formal names of the parties to a lawsuit. The plaintiff is the quote-unquote victim, the person who has been injured, the person who is bringing the lawsuit, who is starting this whole process. And the defendant is the one who has caused the injury, the guy on the other side who is defending himself. So that makes sense, right? Defendant, defending. And here's another place where a lot of newbies get mixed up with the terminology. There will be other titles for parties to or in litigation, I should say. But when you're first filing the civil suit, the cause of action, it's going to be plaintiff versus defendant. That's it. So sometimes you guys might hear petitioner, respondent, or movant, respondent. Those are referring to the parties when they are filing a particular pleading, such as a motion. You know, I alluded to the motion for summary judgment. So if I'm filing a motion, then I'm the movant because I'm moving to file that motion. And then the respondent, again, it makes sense because that person is responding to my motion, right? So the names can change a little bit throughout depending on what is being filed. But when you're talking about the civil suit, the cause of action, when that's initially being filed, the names are plaintiff and defendant and nothing else. The complaint, or like I said, in Texas we call it the original petition. It should sufficiently describe your cause of action so that you could prove to the court, prove to the judge that a remedy is plausible in your case. In other words, you know, judge, we're not filing a frivolous lawsuit, and this is the reason why. Also, it gives the defendant notice as to what he or she may be liable for. After all, how could this person defend themselves if they don't know what they're up against? So that's the reason why there's that rule that you need to sufficiently describe your cause of action. That's the reason why we want to put the elements in there so that we could, A, prove to the court that a remedy is plausible in our case, and B, give the defendant notice as to what he or she is potentially liable for. Now, as far as the remedies go in civil cases, like I said a little bit ago, they usually mean monetary awards, but they could be equitable, such as an injunction. And the monetary damages are considered compensatory because the goal of civil law is to compensate the plaintiff, or like we say, make the plaintiff whole. And what that means is we want to try to put the plaintiff in a position that he was in before the incident took place. Now, realistically, that can't always be the case, but that is our only outlet in civil law, is the award of damages. So that's really the only way that we can try to do this. So if we were to examine compensation in a car accident case, for instance, let's think about some examples of what would be plaintiff's damages. So you're in a car accident, your vehicle is going to be damaged, right? So you can include that as compensatory damages because, again, if our goal is to make the plaintiff whole, we want to put him in a position he was in before the incident took place. Before the accident took place, his car was fine, right? There was nothing wrong with it. It wasn't damaged. So we need to fix that car. So we're going to include that as compensatory damages, the property damage. Underneath property damage, you can also include something that was in the car that was of value, for instance, infant car seat, a pair of sunglasses or reading glasses, any kind of property damage, whether it's personal or the vehicle itself. If that was damaged, you can include that as compensatory damages. If you were injured in the car accident, which many people are, you can include your hospital expenses, doctor bills, ER bills, therapy, whatever it is that you have sought after being injured in this car accident. You can include that as compensatory damages. Also along the lines of property damage, if your vehicle was not able to be repaired, it was a total loss, it was a salvage, they sold it as a salvage, you can include that as well. If the vehicle was not quite a salvage, it was able to be repaired, but there were so many repairs that it has lost value now. You can include that. You can include diminished value as a part of your property damage as well, or compensatory damages, I should say. If you were injured, going back to the hospital expenses, you can also include pain and suffering as a part of your damages. Lost wages because you had to miss out on work. When your vehicle was being repaired, you can include rental expenses, loss of use. So these are all some examples of what would be considered compensatory damages in a car accident case, which is a civil lawsuit. There are some forms of compensation, though, that go beyond just trying to make the plaintiff whole, and they get into a more punishment-like state of tort law, something that actually overlaps with criminal law. And the punishment, so to speak, is the award of punitive or exemplary damages. And these are awarded to deter especially malicious conduct on the part of the defendant. So you guys have probably heard about some outrageous amounts of money that some plaintiffs are awarded from tobacco companies, doctors, pharmaceuticals. Those are all examples of punitive damage awards. So defendant, you have done something so egregious that not only do we need you to pay the plaintiff to make them whole, to put them in a position they were in before the incident took place, but we're going to punish you for this and set an example, if you will, for everybody else in the industry so that they don't injure other plaintiffs as well. So that's the reason why we have punitive or exemplary damages. Now, putting a stop to the outrageous amounts of punitive damages are a major, major factor in tort reform throughout Texas and all the states, really. Defenses, let's talk about those. So we said a bit ago when we were going through the stages of a civil lawsuit, we said that the plaintiff files a lawsuit, and after they file the lawsuit, they have to serve the defendant with process. They have to formally serve them with not only the complaint, but also a citation that's attached to the complaint, and you will ask for this whenever you're filing the lawsuit from the court clerk. And they will issue you a citation. So you will have the constable, sheriff, or private process server formally serve the defendant with this lawsuit, right? And so we said one of the options available were to do nothing. And if the defendant does nothing, then you get a default judgment. However, if the defendant does file an answer, then you go forward in litigation. So that's what we're talking about here, is the answer by the defendant. And there's a couple different ways that this can be done. General denial is one of them. So most times the defendant will respond to a civil lawsuit with this, a general denial. And it basically states, just as the title suggests, I, defendant, generally deny all the allegations set forth in plaintiff's complaint. Boom, that's it, okay? So I filed an answer. I am denying all of the plaintiff's allegations in my answer, okay? There may be some cases that may require an affirmative defense. An affirmative defense is something that's laid out in the rules of procedure, by the way. But these are special denials, if you will, where the defendant is saying, not only do I deny all the allegations, but there was this other thing. There was this independent reason that is responsible for the incident. For example, a defendant can claim contributory negligence on the part of the plaintiff as an affirmative defense. So that's an example of an affirmative defense. Contributory negligence is basically where the defendant is saying that the plaintiff bears responsibility in this incident. So if the defendant is claiming that, then he needs to, that is an addition to the general denial, okay? So if he wants to argue this, then he needs to plead it in his answer as an affirmative defense. So you'll look in the rules of procedure and determine whether or not there are any affirmative defenses available to your client if you're working defense, and go ahead and include it in the answer. Because if you do not, then your attorney will lose the opportunity to argue that at trial. So it's very, very important to remember that. So again, general denial, if I'm filing a general denial, I'm generally denying all the allegations set in plaintiff's lawsuit. So basically I'm indicating to the court, okay, I want to play this game, I've gotten sued, I'm answering this, and I'm putting the plaintiff to his or her proof, right? And what is that burden that we talked about, that proof? It's by a preponderance of the evidence, right? So the plaintiff has to prove their case by that standard. However, if I am claiming that the plaintiff bears some responsibility in this incident, or if I'm claiming that the statute of limitation has passed on this case, and we'll talk about that in just a little bit, that's another example of an affirmative defense. Or if I'm saying that the roadways were slick that day, and I was unable to stop in time. It's not my fault. That's just Mother Nature. Unavoidable accident. That's an example of an affirmative defense. So there's several different examples of what would be considered an affirmative defense. But the point is that if you have one available to you and you want to argue that at trial, then you need to include it in your answer, or you will lose the opportunity to argue that at trial. And I've had this happen before. It happened not too long ago. It was a bench trial, and there was opposing counsel on the other side. And I made my opening statement, and then opposing counsel started his opening statement. Well, in his opening statement, he started to argue contrib. So he started to argue that my insured was actually responsible for this incident. Well, I objected because guess what? He didn't plead that in his answer. And because he didn't plead it, that was my objection to the judge. And the judge sustained my objection and disallowed him from arguing that. So general denial, affirmative defenses. All right, So I mentioned that the burden of proof in a civil case is by a preponderance of the evidence, which means more likely than not. But whose standard is this to prove? And I've alluded to this. It's the plaintiff. The plaintiff, because the plaintiff is the one who's initiating the lawsuit. So it makes sense, right? It makes sense for us to say, well, plaintiff, you're making these allegations, so prove it, okay? But the question comes in, well, are there any instances where a defendant might bear the burden of proof? So we say plaintiff bears the burden because the plaintiff is the one who's initiating this whole litigation. So it makes sense for us to say plaintiff prove it. There are times where a defendant may bear that burden, and one of them is what we just talked about, an affirmative defense. Remember that with an affirmative defense, the defendant is arguing that there is this independent cause, there's this other reason as to why they are not responsible. They, the defendant, is not responsible for this incident. So again, it makes sense for us to say, okay, defendant, if you're making this allegation, well then, prove it, right? So you're stating that you've got an affirmative defense, well, go ahead and prove it, right? Counterclaim would be another time where the defendant would have to bear the burden, and again, it makes sense. A counterclaim is where the defendant is turning right around and suing the plaintiff right back. So if you're suing someone, regardless of who it is, you bear the burden of that case. So the plaintiff would bear the burden against the defendant, and then the defendant would bear the burden of proof against the plaintiff in their counterclaim, okay? So affirmative defense, counterclaim, again, the defendant is making an affirmative statement. They are making allegations at this point against the plaintiff. And if they're doing that, then they bear the burden of proof in those cases, okay? All right, so how is the plaintiff going to prove that they've been civilly wronged? Well, through different types of evidence that you will seek out in your investigation, including witness testimony, any pertinent documents, any physical evidence that's relevant to the case, demonstrative evidence for presentation purposes, such as photographs. Statute of limitation, I mentioned this just a little bit ago, and I said that this is an example of what would be an affirmative defense. So what is a statute of limitation exactly? They are statutes that restrict the time in which a plaintiff can file his lawsuit for particular causes of action against a defendant. And all states have statute of limitation for almost all civil suits, the most common one being 2 years. So that means that the plaintiff has 2 years from the date that an incident that gave rise to a civil wrong took place to file their lawsuit against the defendant. Very, very important. If the plaintiff fails to file within this statutory time period, then his cause of action against the defendant is barred forever. That means he can never ever get it back. That means he can never ever file this claim against the defendant. Okay, so statute of limitations are so very important. They're a time limit that you have to file your lawsuit, and they're going to be different for every cause of action. So you have to make sure that when you get a case, when you have an investigation, you've got that statute of limitation calendared properly. And all law firms are going to have systems in which you can do this, backup systems, because it is so important. Because if one of these slip under the crack and you do not file it within the statutory time period, like I said, that case is gone forever. You can't ever get it back. So you file it, right, and then the defendant files their answer, and in their answer they claim, plaintiff, I'm sorry, but you can't go forward in your lawsuit because the statute of limitation has expired. And the judge is going to dismiss that case based on that affirmative defense, if it's correct, that is. And so guess what happens? Your law firm, your lawyer, is going to face a malpractice claim against that client because that the attorney wasn't able to go forward, and that person has lost all their damages that they could have sought against, the defendant. They've lost that claim. They can't ever get it back. So it's very, very important on the one side to know what your statute of limitation is, to make sure that you get it filed on time. On the other side, it's very important to know the statute of limitation because, again, it's affirmative defense. It's a very, very easy way, if they're past the statute of limitation, to go ahead and dispose of that lawsuit. And you won't ever, ever, ever have to deal with it. So important on both sides, statute of limitations. There's also something called a statute of repose. And what this does is it places a time limit on bringing a suit for certain injuries regardless of when an actual wrong occurred. So we're not looking at when an incident took place, because that's when the clock starts ticking for statutes of limitation, not so for statute of repose. And I should say that not all of you are going to deal with statute of repose. First, not all states have them. Secondly, the states who do have them are not going to have them for all causes of actions, maybe one, maybe two. And like I said, the clock starts ticking on the statute of repose, not when an actual wrong occurred, but say if it's for product liability, say when the product was purchased, that's when the clock starts ticking for statute of repose. Or if it's against a home builder, for instance, then the statute of repose is going to start ticking whenever the home was built, okay? And so if there is, and it's usually a long, time period, 10, 15 years as opposed to 2 years of statute of limitation. So for instance, there might be a 15-year statute of repose or a time limit for bringing forward a claim against a home builder, okay? So again, when that home was built, my statute of repose starts ticking 15 years out, okay? During that 15 years while I'm living in that house, the pipes bust, okay? The pipes bust in the house, that's when my statute of limitation starts ticking, because remember, that's when an actual wrong occurred. So I have 2 or 4 years to file that lawsuit against the builder, so long as I am within my statute of repose, which is the 15 years. So statute of repose is a longer time period that you have to file a lawsuit. And then you have to see if your statute of limitation fits within the statute of repose. And the statute of limitation starts when an actual wrong occurred, as opposed to the statute of repose that starts whenever a product is purchased or whenever a home is built, or again, depending on the cause of action, is going to determine when the statute of repose starts ticking. So I hope that makes sense. Again, statute of repose is a much, much longer time period, and it is not dependent on when a wrong occurred, whereas statute of limitation is. Okay, statute of limitation starts whenever a wrong occurred, or under the discovery rule, whenever you discovered the wrong. And again, there are particular causes of actions where you could apply the discovery rule, and that's getting way ahead of ourselves, but just kind of throwing that out there. As far as criminal proceedings go, the logistics are quite different than their civil counterparts, but I guess you can say the process is about the same. Here, rather than a petition, the defendant will have charges brought against them, but the government's still going to have to prove their case by and through the respective elements of the charge. Remedies are simpler. We mentioned you've got imprisonment and or fines. There is also a slew of defenses that are available to the defendant, especially since there's so much more at stake in criminal cases than civil. However, the criminal defendant will still have to allege and prove their affirmative defenses as they would in a civil case. We said earlier that the prosecution has to prove that the defendant committed the crime beyond a reasonable doubt, which is a much higher burden than in civil cases. Remember, not quite 100%, but it's pretty darn close to 100% sure. The means of proof are identical to civil cases. That's the different types of evidence that can be presented at trial. So witness testimony, pertinent documents, physical evidence that's relevant to the case, demonstrative evidence such as photographs. Criminal cases also have various statutes of limitations, and they're going to be different for every criminal act. you guys are going to get a little practice with this because it is one of y'all's homework assignments for the week. So you'll be able to look up in your jurisdiction, in your state, and see whether or not you have any statutes of repose, and then also statutes of limitation for various causes of actions and how they differ and what those are. A little note about administrative proceedings. The growth of state and federal regulatory environments really puts an emphasis on handling many types of business and policy issues before administrative agencies rather than in the courts of law. So administrative law practice is primarily the practice of representing clients before agencies and in appeals from those decisions. So examples of administrative agencies include the U.S. Environmental Protection Agency, the U.S. Department of Justice, the U.S. Equal Employment Opportunity Commission. And to properly challenge these types of agencies, you want to read up on the statute that controls the agency, the respective rules and regulations, the Administrative Procedures Act, and that is analogous to the rules of procedure that you would consult if you are suing in the courts of law. All right, so now that we have talked about the process of criminal and civil proceedings, let's talk about their resolution. ADR stands for Alternative Dispute Resolution, and as the title suggests, it's a way to resolve legal problems without having to go to court, because there are literally millions of lawsuits that are filed every year, but the vast majority of those lawsuits will never see the inside of a courtroom, and that's because they are settled in their pre-suit or even post-suit filing stages. A negotiation can happen at any point in time during the litigation process up until trial. So I mentioned whenever we were talking about the stages of a civil suit, I said that a case can settle before you even file suit, right? So it can happen in the pre-suit filing stages, but it can also happen all the way up to before you get your jury impaneled. And this has happened to me before. I've had a jury trial and get there, and I've got my client, I've got opposing counsel, they've got their client. The veneer members are there waiting to go through voir dire, which is the questioning of potential jury members. And judge calls me and opposing counsel back to chambers and asks us whether or not we have attempted settlement. And we had, and we were pretty close. And he says to us, I'm not wasting taxpayers' dollars when you guys are not that far apart in settling this. So you need to get on the phone with your respective clients, who are, remember, the insurance company, and go ahead and settle this. So we did just that. And the potential jury members were excused from their service. So negotiation settlement can happen at any point in time. But while we're going through the process, there's a couple formal ways that we can try and resolve these disputes. And one way is through mediation. And mediation is a process where the parties to a lawsuit will use outside help, an unbiased third party that will come in and help the parties to try and resolve the situation. Really what they do is they help to facilitate communication between the parties, because really that's where the downfall is of a lot of these lawsuits, is that parties just cannot communicate with one another without having some kind of outside help. So that's what this mediator does. And mediations can be very formal and they can be very informal. For instance, there's a JP court that I frequently go to. And the judge there, what he does is he has a panel of mediators right then and there in the courtroom, and he makes all the parties mediate their case before they go in front of him for a bench trial. So very informal. He'll kind of dole us out all throughout the courthouse. You know, you go in this corner, you go in this corner, you go in this room, you go in this back room, you go in the back, you go in the front. And we talk to this mediator who is a volunteer. They don't get paid for their time, but they're just trying to get experience and help people out. And we talk to this mediator and we try and come up with some kind of settlement. And if it's settled, fantastic. The mediator cannot dictate an actual decision. So again, it's the parties that are coming up with a resolution. And, you know, the judge tells the people before, he tells the parties before he gets us to mediate, he says, you know, mediation is a good thing because you've got your fate in your hands at this point. You guys can compromise to come up with some kind of resolution. I, on the other hand, will not compromise. I will just go down the letter of the law and I will make a decision. I will not listen to emotions. I will not listen to any other pleas. I am just going to listen to the legal facts and make a decision based on the rules of law. And so a lot of judges really push for mediation because it is extremely effective. So that JP judge, he has basically mandatory mediations. He tells them, you don't have to settle, obviously, but you do have to talk. So he makes you mediate. Also, I practice in Fort Bend County as well as Harris County, and in Fort Bend County, they have a county order that states that you have to mediate cases before you can even get a trial date. And so, whereas, you know, once upon a time, many years ago, mediation was kind of looked down on, you know, parties, people just didn't like to go through mediation. But there's been a lot of groups, a lot of judges that have gotten together, lawyers that have really pushed mediation through the years. And again, it's very successful, especially in, you know, in our cases, it really helps a lot. I would say 90 to 95% of our cases settle. And then also in family law, for instance, because family law, and we mentioned this on the very first day because several of you are interested in going into family law, which is fantastic. But, you know, we said how emotions really run high with family law cases. And so, again, if you've got this third party that is not connected to anybody that is involved in the suit whatsoever, and they can get the parties to calm down and just talk, then a lot of times you could come up with a resolution, even if that resolution just means an apology. And believe it or not, that has happened before. And so you will have, I mentioned about the informal mediations, you also have formal mediations where you'll go to the mediator's office or somewhere, and the mediator will meet with both sides. Both sides will make an opening statement, just like you would in court, for instance. And then the mediator will, it's called caucus them out, separate the parties into two different rooms and talk to them individually, separately. And they'll play devil's advocate, but it's all confidential. So the mediator will not share anything that you have told him with the other side if you do not want him to. And at the end of the day, you can't go into the court and say, well, this person said this in mediation. Again, it's all confidential. And the reason why they have this, again, it's very obvious because it helps to facilitate communication that will hopefully resolve this dispute, right? So that's mediation in a nutshell. Arbitration is in between, I would say, it's similar to mediation, but it's also similar to having your case tried in a court of law. So it's right in between. Arbitration is a resolution of a dispute by somebody other than a judge. This person is called an arbitrator. However, this person's decision is binding, unlike the mediator, right? So it's very similar to a court of law in that you go in, you make the opening statements, you present the evidence, this person makes a decision, and that decision is binding. And so a lot of times what happens is parties will agree through a written contract that they have to go through arbitration if there's a dispute in relation to that contract. A lot of companies will routinely include an arbitration clause in their contract. So if you go and look at your cell phone agreement or your credit card agreement, you will most likely find an arbitration clause. And basically, when you sign that, you are stating, I am foregoing my right to sue in the courts of law. And if I have an issue with this company, then I am going to have to arbitrate this dispute. And the arbitrator will make the decision, and that decision will be binding. And the reason why parties do this is because it is faster, usually, essentially. It is cheaper, and we're not clogging up the already clogged court dockets out there. And so it is a wonderful alternative to a dispute resolution out there, rather than going through the courts of law. You know, so many times we have cases and they don't go to trial until years after the incident took place. And I always have, you know, whether our insured or defendants commenting about this. This happened 2 years ago, as if it's supposed to go away. Well, it took that long. It took us that long to go through informal investigation, to go through filing of the lawsuit, finding you, serving you, having you file an answer, go through discovery, and then get to trial. It takes a long time. And so arbitration, mediation, those forms of ADR are quicker, and they are easier, and they're cheaper, because it's very, very expensive to have a lawyer go through that whole process and get to trial. You're going to be paying out a lot of money rather than just going through arbitration and having the decision made there. So let's talk a little bit about informal investigation and discovery. Once the suit or criminal charges have been filed, the parties can engage in discovery, which again is the uncovering of pertinent evidence in a case. But before suit or criminal charges are even filed, there's a strong possibility that you can uncover a lot of this evidence and use it to your advantage, say, to settle the case, prior to incurring any costs associated with litigation. So we just mentioned how that can get pretty expensive, right? So the advantages of informal investigation are that you can bypass all the formal rules of procedure in regards to discovery. It's cheaper, less time consuming, and if you're gathering the physical evidence and talking to witnesses early on, then the events are pretty fresh on everyone's mind, so you avoid problems of memory fading about important facts or evidence getting lost. I will mention this. Once you are in practice, you will sometimes become extremely jaded by the whole process of investigation and discovery, because it is a lot of hard work, And all that hard work that you put into the case, your boss is going to come by your desk one day and drop the file and say, drop the settlement papers, this case has been settled. And you're going to think to yourself, what a waste of time. All that work I put into that investigation, all those people I talked to, all of those documents that I drew up, especially once you get into discovery, all that stuff that I filed with the court and I sent to the other side, and the case is settled. Well, just know that settlement is not a bad thing. In fact, that is your goal. The only way that your attorney got that case settled in the first place and therefore resolved is through a thorough investigation on your part. So if a case settles, then that means that you did your job really well, not that your job was a waste of time. Because the thing is that you never know how a case is going to end up at trial. Never. Not even when you think it's a slam dunk. So going to trial should never be your end goal. That is our last resort. So it behooves you to work towards the goal of avoiding trial by getting as much information about a case as you can, and then using that information to settle that case outside of the courtroom. So it follows then that early investigation of the case is important for a number of reasons. First of all, like I said, the incident that occurred is fresh on everyone's mind, so the faster you can obtain the evidence, the more reliable it's going to be. Like I said, a lot of times you have cases going to trial that happened years ago, so obviously people's memories fade, documents get lost in the shuffle, witnesses may no longer be available, maybe they died or they've moved out of the country. So that's why you want to get in on the information as quickly as you possibly can and then use that information to try and go ahead and get that case settled. All right, so now that you have completed your informal investigation, what are you going to do with it? Well, you need to find out if you have a case to start out with, right? How strong your facts are, decide if they're legally supportable, because we don't want to file a frivolous lawsuit. We need to make certain that we have a valid claim in law and fact in which to proceed. And just as we discussed in Chapter 1 with the factual analysis, all legal teams need to use pre-filing investigation as a tool to decide what kind of case they have, how strong their evidence is, how they're going to defend, what damages can be proven, and against whom they're going to pursue the action. Identifying potential defendants is important, and these are one of your objectives of pre-filing investigation, because you want to find, or you want to make sure that you get the right guy. For example, we stated, and you now know that you are the agent of the attorney that you work for under the principle of vicarious liability, right? Well, the same goes for most working relationships. So if you've got an employer-employee relationship and you are working during the course and scope of your employment with that employer, well, then your employer is going to be responsible if you have committed some kind of tort, okay? So if you are a paralegal and you are investigating a car accident, you're looking over the police report and you see that the defendant has a commercial driver's license. What do you think you're going to do with this information? You're looking at the police report, defendant has a commercial driver's license. We're talking in terms of identifying potential defendants. What you want to do is you want to delve a little further into that. Determine, well, if this guy had a commercial driver's license, was he driving a commercial vehicle at the time of the accident and therefore was in the course and scope of his employment? Because if that's the case, then like I said, you can include his employer as a defendant. So now because of your investigation, your attention to detail, you've got quote-unquote deep pockets to go after and somebody that is more likely to satisfy a judgment on behalf of your client than that defendant driver is. So one of the things, another one of the things as far as pre-filing investigation goes is you want to find out whether or not your defendant is judgment-proof, as we say. Can this defendant pay out on a judgment? Because if not, then if you do an asset check and you determine that this person has absolutely nothing to give and no potential for future income or current income to pay out on a judgment, then that judgment really is just as good as the paper it's written on. So that's one of the things that you want to determine. So if you've got a company, if you've got an employer, then again, that person or that company, that defendant, is going to be much more likely to be able to pay out to your client than the individual driver is. So some things that we're going to talk about here with pre-filing investigation. This is basically going to be a prelude to your next civil procedure class. And I think I mentioned this on the first day, but I'm going to repeat it a couple times because, again, I don't want you to ever feel overwhelmed by this information. But remember that this is an intro class, basically. So we are being introduced to a lot of these concepts as far as investigation goes, litigation process, discovery, and things of that nature. So I will introduce it to you, and then you will build off of this and really learn all the details that go into these things in your procedure classes, okay? So the next couple of things that I'm going to talk about, just keep that in mind. I'm going to introduce them to you, and then you're going to learn these in length in your civil procedure class. Jurisdiction is one of the things that you need to keep in mind with pre-filing investigation. And jurisdiction is the authority that a court has over a problem. And there's two different kinds of jurisdiction. There's personal jurisdiction and there's subject matter jurisdiction. Personal jurisdiction is the authority over a person. So again, as the title suggests, person, personal. And the test is whether or not the parties have had meaningful contacts with the place where the court is located. So, for example, in a car accident case, you can file where the accident occurred because the parties can reasonably be expected to be sued there. They've passed the test. They've had meaningful contact with that place where the court is located, right? So that's personal jurisdiction. So that's, again, whenever the defendant is personally served. Do I have personal jurisdiction? Can I serve this person here? Subject matter jurisdiction is the power of a court to hear a particular problem, or subject matter, if you will. So it's right there in the title. A court has no power to decide a case outside of its subject matter jurisdiction, because if it does, then it's null and void. There are two types of subject matter jurisdiction as well. There's general and there's limited. So general subject matter jurisdiction is all in one. It includes all the different practices: criminal law, civil law, family law, probate, whereas limited subject matter jurisdiction deals with narrow, specialized areas. So you have one court, one judge for only civil cases, one court, one judge for only criminal cases. And so this usually comes down to the size of the county or jurisdiction that we're talking about. So, for instance, I mentioned a little bit ago that I practice in both Harris County and neighboring Fort Bend County, Texas. And in Harris County, when I go downtown to the courthouse there's a big, beautiful civil courthouse, and all of those judges in that building can only hear civil cases. So they have, limited subject matter jurisdiction because they're limited to only civil cases, right? Right next door to them is a big, beautiful criminal courthouse building, and in that building, the judges in there have, again, limited subject matter jurisdiction to only criminal cases. So I can't go next door and have one of those judges hear my case, because if they do, again, like I said, it'll be voided. So in a limited subject matter jurisdiction case, probate court, for instance, has no subject matter jurisdiction over a divorce. That's left entirely up to the family law court to decide, okay? In neighboring Fort Bend County, Texas, however, when I go to the courthouse there, they are general subject matter jurisdiction. So that same judge that is hearing my car accident case is also hearing criminal cases, is also hearing family cases, is also hearing probate cases. So very, very interesting. General, they hear it all. Criminal, civil, family, probate. And then limited is, again, limited to particular subject matters. Only civil, only criminal, only family. Does that make sense? So jurisdiction, again, the authority of a court, the authority a court has over a problem. Two different kinds, personal and subject matter. Personal is the authority over a person. Subject matter is the power of a court to hear a particular subject matter or issue. And then under subject matter jurisdiction, you've got general and limited. And general is all in one. It includes all subject matters. Limited includes just one particular subject matter for each jurisdiction. Venue. Venue is the actual location of trial, and you have to look at the statute in your jurisdiction to determine which venue is proper. In Texas, for instance, venue is proper either where the event occurred or where the defendant resides. Those are generally the two places that you could file a lawsuit, or where you have proper venue. What if you're suing the government? Well, there are some special considerations if you're suing a governmental agency. There's something known as, or there's a concept known as sovereign immunity. Up until about the 20th century or so, governments were actually immune from liability for torts that were committed by their employees. And this is referred to as sovereign immunity, or in modern times, governmental immunity. But now, since the legislature has enacted statutes such as the Federal Tort Claims Act that specifically authorizes lawsuits against torts committed by governmental employees. So governmental employees can be sued for certain torts. You have to look up the act, look it up in your jurisdiction to determine whether or not the government can be sued for your particular cause of action. Once it has been determined that they can be sued, then there are some special considerations that need to be followed in pursuing that agency. So there may be some notice requirements. For instance, in Texas, you have to give the governmental agency, I believe it's 6 months notice before you sue them. So if you don't do that, then again, you may lose the opportunity to go ahead and sue that defendant. So just like you would check out the local court rules to see if there's any special procedures, you would do the same thing for governmental agencies, okay? All right, so that is the end of Chapter 3. And again, Chapter 3, we just went over the entire adversarial system in a nutshell, really. Alternative dispute resolution, or ADR, various ways that we can resolve disputes without having to go to court, and pre-filing investigation. So that is Chapter 3. If you have any questions about this content at all, please feel free to contact me, to email me, and I will get back to you. Thank you so much.